Members, the question is that the motion be agreed to.
Mr Speaker.
The Honourable David Parker.
Thank you, Mr Speaker. I rise with pleasure on behalf of the Labor Party to say that we are supporting this piece of legislation. Sir, can I reiterate the comments that Mr Brownlee has made, thanking those people throughout the area and actually further afield who are doing their utmost to help the people affected by the earthquake. A lot of people obviously helping themselves, but others also pulling out all stops to assist the people who've been adversely affected by the earthquake, to try and minimise ongoing safety risks, trying to also assist the putting back together of the infrastructure, the homes and the other repairs that are needed to allow life to return to normal. Sir, this is an important bill, and I want to give an illustration of what I think is going to be one of the most practical the practical issues that's faced under the legislation. Sir, we've all seen the photographs of the enormous quantity of debris that is covering the roads and the railway, blocking State Highway 1, and as Minister Brownlee has said, has had the consequences of diverting traffic at much longer routes, much less convenient routes, much more costly routes, and routes that weren't designed to have that much traffic. The government, I think, has already indicated that they are likely to restore State Highway 1 from Kaikōura through to Picton. They're expecting to have the section south of Kaikōura opened in a not too distant future, but the huge job of getting it open between Kaikōura and Picton is one that's going to arrive, it's going to be enormous complication. One of the complications is that there are so many slips, it seems to me, that it's going to be likely that the repair work has to be done at the same time for different slips. So they'll be working in the middle of this as well as at the ends, when they won't have access restored for very long sections of road. So what do they do with the spoil? Now, already on the bill that we heard yesterday, there were representatives from the inshore fishery and from the power industry saying we've got to be very careful that we don't produce more fine sediments, don't drop a lot more fine sediments into the sea area, because we could be ruining or further damaging unnecessarily the paua fishery or the lobster fishery or the environment more generally. But on the other hand, where do you put it? You can't actually. I would have thought it's very difficult to barge it all away. Maybe that is a possibility, but I would have thought that's pretty impossible. So the question as to what's going to be done there is going to have to be grappled with by the government, and it seems likely, it seems almost certain that they're going to have to override certain normal provisions that would apply in respect of those decisions. Now, that's not to say that they shouldn't have regard to the environmental consequences and do it in the best way that is possible, but they are going to need special powers, and it's not yet clear that the special powers that will be needed moving forward are available under the existing legislation, and that's one of the reasons why the Parliament is deciding whether it should confer additional powers to the Executive under this bill to override primary legislation, and I think that's an appropriate thing to do. Having said that, we should always be very careful when we're overriding the things that are meant to be controlled by primary legislation. And the Regs Review report on this, I think, makes the best example in our history, or the worst example actually, and that is that the Economic Stabilisation Act was passed in 1948 with a broad regulation-making power that was intended to be short-lived. It effectively was so broad that it allowed another government, 30 years later, the government of the Right Honourable Robert Muldoon, to by statutory regulation impose a price freeze and a rent freeze and a wage freeze upon the whole of the country through a regulation. Patently should have been done, if at all, it was a silly thing to do, but if it was to be done, it ought to have been done through parliamentary legislation. That is an example of why you've actually got to be very careful that you don't confer powers on the Executive that will be used in ways that were not expected when they were first created. And so my view of this is a bit like taxation. When it comes to overriding government legislation in an emergency situation, it's a bit like taxation. As little as possible and as much as necessary. So we've got to give the powers to the Executive to override primary legislation in a way that is as little as possible, but as much as is necessary. And getting that balance right is what we're trying to achieve through this legislation. We're lucky, sir, or unlucky, we are unlucky to have two recent instances where Parliament's previously attempted to do this, which was in 2010 and 2011 in response to the earthquakes, which tragically saw much greater loss of life in the Canterbury region. And on both of those occasions, there were criticisms of the legislation, although on both of those occasions, I think we all acknowledge in this House that the excessive powers that were conferred upon the executive were not abused. They weren't abused, but the possibility of their abuse existed from the breadth of the legislation. And there was quite a bit of criticism, particularly of the 2010 legislation. The 2011 legislation was an improvement on the 2010 legislation. It included some checks and balances, including a review committee whose views had to be taken into account. And that mechanism has been carried forward in this legislation, and that's a very good thing. I personally think these are so serious things, you should always have a judge on the review committee. I don't think it should just be some minor lawyer. There's lots of minor lawyers who wouldn't be good at it. We had at the Select Committee on the Security and Intelligence Bill today, Sir Bruce Robertson in front of us, who's the Inspector of Warrants there. And you just see how experienced judges from our senior courts are so much cleverer than a junior lawyer who could otherwise be appointed to these roles. So, and it was, what's that? No, I don't think you want that on record. Excuse me while I regather my thoughts. So the role of a judge, we've got plenty of retired judges who can do this sort of thing if it's not suitable for a current judge. So I think I would hope that the Select Committee look at whether we should require that one of the review committee members be a judge. I don't have a view as to how big the committee should be. I don't think it should be too big. I think the people that should sit on it, I think 3's the suggestion, that's good. The pool of people from whom they're drawn can be bigger. I don't have a strong view as to that, although maybe it needs to be a bit bigger than if it was just a small geographic area that was being considered, if there is a case for some geographic representation. Sir, as little as possible and as much as necessary. Well, the way the second bill in the Second Act in 2018 tried to put some controls was it had a list of assets that couldn't be overridden, including the Bill of Rights Act, for example. But beyond that list, anything could be. Again, that was too broad. And the Regs Review Committee has recommended that we actually have a positive list in the legislation as to what can be overridden rather than leaving it to open slather, again subject to again with some things that cannot be overridden even through that process. Is the list too long or is it too short? That is to be considered by the Select Committee. I just want to, in the short time I have available, say that I'm not sure that we should allow that list to be lengthened through a regulation-making process rather than bringing it back to Parliament. Once it's done, it's very hard for the government of the day to actually concede, oh, well, maybe we got that wrong. It's much better, I think, that you have parliamentary scrutiny if you're going to add to that list. It's already a very long list, and if there is a need to change it, well, the government under urgency could just add something to the list in one debate, essentially, as we've done with other legislation here in respect of an addition such as that. Sir, the submission period, I'm a little disappointed that we've got a report back by Wednesday. Is it? Tuesday? Tuesday. I don't know why that couldn't be next Thursday. We could have still passed the legislation through later. It's one of the points that the Regs Review Committee made. I know how difficult it was for a less important bill that we considered yesterday. We've been working very long hours to try and knock that one into shape, and it was a good bill when it came to us. I would have thought we could have allowed ourselves a few more days to do that and therefore allow people who were interested in these issues to make submissions. I think by the time they read the Regs Review report, they reflect how good this legislation is, how it's a further improvement with more checks and balances compared with the prior pieces of legislation. A lot of them, if they actually have the time, will say, well done, but we're hardly giving them the time to say that. So, sir, with that, can I agree that that this legislation is necessary, and I look forward to scrutiny of this legislation at Select Committee.